Thank you, Senator Blumenthal. I'd like to thank all of the nominees who appear before us this morning. Thank you for the opportunity to join what I understand has been a vigorous exchange with other members of the committee. And I'd like to thank Senator Blumenthal for chairing today. First, if I might, I'd just like to ask each of you in turn if you would offer what comments you wish on what role you think you would have as a member of the federal judiciary in ensuring equal access to justice and ensuring fair and balanced treatment of all litigants who might appear before you, and what in your experience gives us some confidence that you will make that a priority in your service.
Thank you for the question, Senator. Equal access is kind of a broad topic. I view it, equal access to the court, as being a model of efficiency, and that is that the judge has an obligation to move cases through the system so that cases don't languish, so that litigants have an opportunity to bring closure to their cases. The efficiency of the judicial system is bent on that, and I think it's necessary. You have corporate litigants that have no closure to cases because cases aren't moving, and so equal access means a lot of things. It means that the judge should remain active to me. The judge should remain active in the case, move cases forward, set reasonable deadlines, but also move the court into a system that is more efficient. And that may mean, for example, when I was a trial court judge, I developed a drug court program to move some of the felony cases off the original docket, the main docket, criminal docket. It also may mean that I supported pretrial diversion programs. I supported mandatory mediation in civil trials where juries had been requested. All models built on allowing equal access by improving how quickly people could get to court. With respect to ensuring everyone is treated fairly, I think the best evidence I could give you of that would be my record as a trial court judge and an appellate court judge, where I have an unblemished record of having ensured that everybody that appears before me is treated equally with an unbiased and an impartial application of the law to the facts of their case. And that is what has prepared me, I think, to model that if I were fortunate enough to get confirmed on the district court.
Judge Boggs, if I might, I have a few questions rooted in your record that I wanted to get to, if I might.
Yes, sir.
You cast a vote when a member of the Georgia legislature to approve posting profiles of abortion doctors online. And there's been some exchange about that. What, in your opinion, motivated your vote for that measure? And how could I understand that measure as being anything other than an intent to burden a woman's right to choose?
Thank you for the question, Senator Coons. I was motivated by a very strong desire to represent the will of my 38,000 constituents in South Georgia who were predominantly pro-life. Those issues were important to my constituents. That amendment, albeit an amendment that I didn't have very much time to consider and for which I have expressed regret for not having been more considerate of that vote, in the end of the day, the motivating factor for my vote on pro-life issues in general was motivated by my desire to represent my constituents.
You, in 2012, completed a judicial questionnaire in your application to the Court of Appeals on which you now serve, and you stated, and I think I quote, "The judiciary continues to endure criticism, fairly earned in some cases, of abrogating their constitutionally created authority by issuing decisions that venture into policymaking." This is the question of activism by the judiciary. If you could, just help me understand, did you believe the Georgia Supreme Court was being inappropriately activist when they struck down Georgia's sodomy law in Powell versus State, or the U.S. Supreme Court in Lawrence versus Texas, were they being inappropriately activist in the way you detailed there?
No, sir.
Could you name 3 or 4 cases where you believe the judiciary has fairly earned criticism for, as you put it, abrogating their constitutionally created authority? What cases did you have in mind?
At the time I made not necessarily those comments, but other comments on the floor of the House as a legislator, I had in mind judges that were declaring same-sex marriage as constitutional, candidly. That's what I thought as a legislator. That's the cases that I was referring to, those states where judges had declared that law constitutional. Looking back on that, particularly now, 13 years later, and particularly now with the benefit of having been a judge for 10 years, the concept of activist judge that I had as a legislator is no longer prevalent in my mindset.
You said, I believe, earlier today in an exchange with Senator Blumenthal that it would be inappropriate under Georgia's canon of judicial ethics, or perhaps under the federal canon of judicial ethics as well, to convey to this committee where you stand on particular issues. Yet those same canons would have applied to you as a judicial candidate in 2004 when you made a public announcement in a candidate form about where you stood on issues like same-sex marriage. Was that a violation of the canon of judicial ethics?
I don't know. I would leave that to the Judicial Qualifications Commission in Georgia. I will tell you that in looking back on those comments made while I was still a legislator, but also seeking the job of judge, and candidly probably after I had qualified for the position of judge, I regret that I wasn't more articulate and artful in crafting an explanation to my constituents that reflected my understanding of the role of a judge, looking back on it.
The Georgia canon of judicial ethics states a judge or candidate for election to judicial office shall not make a contribution to a political organization. Now, a political organization is defined as a political party or group, the principal purpose of which is to further the election of a candidate to office. Would you consider Georgia Conservatives in Action to be a political organization under that definition?
Senator, I'd have to look at it. I'm familiar with that organization, but not enough with regard to tax status and otherwise to determine if they meet.
You're familiar with it because your campaign committee perhaps made a contribution to it in September of 2012. And my understanding is that Georgia Conservatives in Action endorses political candidates, including a candidate for the U.S. Congress. And that is an issue that is of some concern to me in terms of crossing, sure, I think, a line that's fairly clear. Canon 7A of the Georgia Canon of Judicial Ethics also says that a candidate shall not publicly endorse a candidate. When did you announce your candidacy for Superior Court Judge?
Senator, I don't recall. It would have been in sometime in 2004.
And at that point, were you a member of the Bush-Cheney Democrats for Bush National Steering Committee?
To my knowledge, I had never been a member of that committee. It was only throughout this process that I discovered I had been listed, and I believe my listing, without my permission or even knowledge, was by virtue of me having attended a meeting prior to President Bush's fundraiser in Georgia. I didn't attend the fundraiser. I didn't make any political contribution. I did go back, and having now seen that, I was a member of that committee 13 years later, and realized that everybody that attended that, with the exception of one member, was listed. Again, it was done without my authority. I had no knowledge of it. And as to your comments back on Conservatives in Action, at the time I made a contribution from my campaign, judicial campaign, to Conservative in Action. I had no knowledge of their sponsorship or endorsement of any candidates for elective office.
I appreciate your answers to these questions. I may have others for the record, and Mr. Chair, I appreciate your forbearance and the time I've taken. I do think there's a voluminous record here that well bears consideration. I appreciate your testimony today.